This is a very important conversation we're going to have here today about the constitutionality of immigration legislation, the state of state laws. I'm Caroline Fredrickson. I'm the president of the American Constitution Society. I'm very happy to be here in Atlanta for this very, very important symposium that we're going to have here today. For those of you who may not be familiar with the American Constitution Society, we are a national network of lawyers, law professors, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. We work for positive change by shaping debate on vitally important legal and constitutional issues through the development and promotion of high-impact ideas. One of our top priorities is bringing attention to the importance of the courts and the real-world impact of judicial decisions on our lives. Today's conversation is the perfect example of that effort. And we'd like to express our deep gratitude to the Ford Foundation for helping to make it possible. In 2011 alone, 1 year after Arizona passed the notorious SB 1070, 5 states enacted restrictive immigration laws that were challenged in federal courts across the country, 3 of them here in the Southeast. These cases raise serious questions about the nature of our federal system with regard to what states can and cannot do. And of course, underlying these deep legal questions are the issues of how our nation of immigrants treats its newer immigrants. Today, we are extremely lucky to have leading experts and advocates to guide us through these sometimes complex and often politically fraught issues. This morning, we will have a panel of national experts, some of whom write about these issues, and some of whom are trying the cases we'll be talking about. At lunch, we'll be very privileged to hear from Assistant Attorney General Tony West, who is spearheading the Department of Justice's challenges to the state laws in question. And this afternoon, we'll hear from regional advocates who will tell us how these issues are playing out on the ground and for real people. This region knows firsthand both the legal and practical implications of these laws. And I know many of you who are here in the room have been actively engaged in these debates. One of our hopes is that this symposium will not just be a learning opportunity, but also a networking opportunity and an opportunity for strategizing and developing new ideas. So we hope you will stay for the last hour and introduce yourself to others whom you may not know so that we can build a tighter network and a stronger community. So to start us off, we are going to have our first panel discussion this morning. And I am very, very pleased to introduce someone who is a friend to me and, more importantly, to the American Constitution Society and to the Constitution itself, Neil Kinkopf. Neil is a professor of law at Georgia State University College of Law, where he teaches constitutional law, legislation, and civil procedure, and he's directed the Center on State Legislation and Policy. He served as a counselor to the Senate Democrats during the impeachment trial of President Clinton and was recently special assistant in the Department of Justice's Office of Legal Counsel, where his practice focused on issues of presidential power. He is a frequent commentator in both the national and local media and has written numerous articles on law and politics. So I'd like to welcome Neil and the panel up to the podium. Thank you.
Thank you, Caroline, for that most generous introduction. And thank you all for being here today for this very important conversation. I know Arizona is much in the spotlight with its immigration reform laws, but I really think the Southeast has become sort of the epicenter for state regulation of immigration, with seemingly each state trying to outdo its neighbors in just how restrictive and punitive it can be with respect to immigration. And so to discuss some of the issues that arise from those laws, both here in the Southeast and nationally, we've assembled a terrific panel of experts. I will briefly introduce them, but only briefly, in part because I want to save time for this important conversation, and in part because if I did give you their full bios, that would make the one Caroline just read pale terribly. So to my left, we have Cecillia Wang, who is the director of the ACLU's Immigrants Rights Project, and I think she may be the busiest woman in America litigating challenges to all of these terrible laws. To her left, we have Jack Chin, who is a law professor at University of California, Davis. Professor Chin specializes in immigration law, race and the law, and not constitutional law, but he knows a lot about it and is going to tell us about that. To his left is Pratheepan Gulasekaram, who teaches at Santa Clara Law School, and he specializes in immigration law and constitutional law. And then lastly, we have from George Washington Law School, John Siegel, who wanted me to let you know that he doesn't specialize at all in immigration law. He comes to us as sort of a constitutional generalist with a fresh, unburdened perspective on these issues. So I want to start by talking to Cecillia and to ask you if you can give us sort of an overview, a status report on litigation that's pending out there and sort of the status of that litigation.
Sure. I'm happy to do that. And actually, let me put up a map to help do that. So as Caroline mentioned, these state efforts to regulate and enforce immigration law really hit the public eye in the spring of 2010 when Arizona passed SB 1070. And then the following year, last spring and summer, we saw at least 5 states follow suit with laws that could be characterized as an SB 1070 copycat. But really the story starts a little bit earlier. Back in 2006 or so, anti-immigrant activists, including the organizations FAIR and Early, started churning out model legislation for cities and municipalities to use. And so we've all heard about the Hazleton, Pennsylvania ordinance that prohibited undocumented immigrants from renting homes or from being employed, and other cities like Valley Park, Missouri, and Farmers Branch, Texas followed suit. But to fast forward to what happened after Arizona passed the first of the state omnibus immigration laws, last spring, immigrants' rights advocates and civil rights advocates around the country watched in alarm as the state legislative session started in January and February. We were confronted with a landscape where there were 24 or more states threatening to introduce legislation. And to make a long story short, the outcome was what you see reflected on this map. In about 14 states, the untold victory was that state anti-immigrant legislation was defeated. Those are the states that are colored blue on the map. And then you saw 5 states, in addition to Arizona, passing state anti-immigrant laws, and those are the states labeled in green: Utah, Arizona, Alabama, Georgia, and South Carolina, as well as Indiana, which had a slightly scaled back version. Now, the good news is that those states are colored green on this map because in every single state that passed one of these laws, key provisions of the law were enjoined by district courts in litigation that either we brought as part of a civil rights coalition or in response to the Justice Department's lawsuits. The current status, as you all know, is that all eyes are on the Supreme Court, which is considering SB 1070 itself. There are 4 provisions at issue there. And the status in the other states is that we have our preliminary injunction hearing in Utah next Friday, where a TRO has been in place since the day that the law was to go into effect. In the other states, injunctions are in place against key provisions, with the exception of Alabama, where, although key provisions were enjoined, the basic show me your papers law, the provision that requires police officers to check status during traffic stops and other encounters, was not enjoined by either the district court or the 11th Circuit. And there you have it.
I feel like we're singing a duet here. So can you tell us a little bit about the substance of the laws that are at issue, right? What's being challenged, what's out there, and significant variations between states?
Sure.
So in the Supreme Court case, U.S. versus Arizona, we have 4 provisions that are at issue. All of these are common to many of the state laws that have been passed. First, there is a state criminal offense for failure to comply with the federal alien registration law. There is what we call a show me your papers provision, which, as I said before, requires state and local officers, upon reasonable suspicion that a person is an undocumented immigrant, to verify their status, which we've alleged in these lawsuits, and the Justice Department as well alleges will result in prolonged detentions at the side of the road while immigration status is checked out. We have various kinds of provisions that penalize employment of undocumented immigrants, either on the employer side or, in the case of Arizona and Alabama, criminalizing being undocumented and working, which is in direct conflict with Congress's scheme for the employment of immigrants. And then finally, there are warrantless arrest provisions that are at issue in Arizona and the other cases. Now, we've all heard that Alabama's HB 56 goes well beyond those 4 provisions that are at issue in the Supreme Court in the Arizona case. Alabama legislators explicitly undertook a comprehensive state law to drive undocumented immigrants out of the state of Alabama. So in addition to these criminal provisions and employment provisions, they have enacted what I call civil death provisions. These are provisions like Section 27 and Section 30 of HB 56 that render void any contracts where the parties know that one of the parties is an undocumented immigrant, and also prohibit so-called business transactions, which have been broadly defined by the legislature to include almost any kind of interaction between an individual and the state. So, for example, we've had to bring a separate as-applied suit to challenge the application of that business transaction provision to people trying to renew their annual license for mobile homes. So the law is literally meant to get rid of undocumented immigrants throughout the state, attacking them at every level of everyday life, while you're driving out on the road, while you're trying to renew your driver's license, while you're trying to engage in a rental contract, and while you're trying to work. And obviously, a key component of the preemption arguments in all of these cases is that while the laws are meant to target undocumented immigrants, they cast a wide dragnet that violates the civil rights of U.S. citizens and lawful immigrants as well.
Great. Just one last question, and that is, who are the parties bringing these lawsuits? And within that, you know, the most famous of the lawsuits is Arizona versus the United States, right? So the United States is involved in that lawsuit, but not involved in all of the lawsuits. And I'm wondering if you could talk a little bit about where they are in, where they aren't, and maybe why they're in some and not others.
Sure. In the 6 states that are labeled green on this map, civil rights coalitions brought lawsuits first to challenge all of these laws. The ACLU and the National Immigration Law Center were partners on all of these cases, and the Southern Poverty Law Center, MALDEF, and many other civil rights organizations joined in the coalition effort in all of these states. In all the states except for Georgia and Indiana, the Justice Department came in later to file suit after being publicly called upon to do so by the civil rights coalitions and other civil rights organizations, as well as members of Congress. So the missing pieces, as far as the Justice Department is concerned, are Georgia and Indiana. Now, I bet you're going to ask me why that is. You should ask Tony West when he talks to us later on today. But the observation I would make is that the Justice Department has, in its preemption arguments, relied heavily on the fact that the state laws, by and large, impose a mandatory requirement on state and local officers to check immigration status out on the streets. Georgia's law does not require that as a mandatory matter. The Georgia law gives officers in this state discretion to check immigration status or not. And so that could be reading between the lines of their arguments in the states where they have filed suit, a distinction that makes a difference to the Justice Department. Of course, we as civil rights lawyers don't see that distinction making a difference. The fact that a state law has empowered state and local officers to do those status determinations and to hold people while doing so, we believe is a serious civil rights issue and violates the Constitution.
And I think Judge Thrash agreed with that in his ruling. Jack, I was hoping we could talk a little bit about some of the issues that are raised in Arizona versus United States, and especially preemption, but not limited to preemption, right? So Arizona versus United States, of course, is the lawsuit challenging Arizona's SB 1070. What are the constitutional issues that law raises?
Well, there are a number of them, obviously, and so the one that has been most frequently articulated is preemption. That is to say that SB 1070 is invalid because, to some extent, it is inconsistent with federal law. Preemption, as many of you remember from law school or elsewhere, has three varieties. Express preemption, where Congress says all state law in this area is preempted. Conflict preemption, where federal law requires or prohibits something and state law requires or prohibits the opposite. And field preemption, where Congress passes a systematic regulatory scheme that doesn't expressly preempt state law, but it's so comprehensive and so broad that it implies that state law, even that doesn't conflict, is impermissible. And I think there's a very strong argument that SB 1070 type laws are preempted because they're designed to take people who are in the United States unlawfully without authorization under the Immigration and Nationality Act. They're designed to compel them to self-deport. The phrase that SB 1070 and some of the other laws use is attrition through enforcement. It's designed to make life so difficult for these people that they choose to go to some other country or to some other state where these laws don't apply. And the reason that I think, and I think the key argument that others make that this is preempted, is because the Immigration and Nationality Act doesn't work that way. When we're dealing with an undocumented person under the Immigration and Nationality Act, the Departments of State, Homeland Security, and Justice are given a range of discretionary choices to deal with that person. They can file criminal charges. They can, without filing criminal charges, civilly deport them. They can do neither of those things and ask them to leave through a process called voluntary departure. Those are the negative things that can happen to an undocumented person who comes into the federal enforcement apparatus, but there's also a number of good things. There is sweet as well as bitter in the Immigration and Nationality Act. Someone with no claim to legally be in the United States, that is, who doesn't claim I have a visa, I'm a U.S. citizen, I am a lawful permanent resident, can nevertheless be granted asylum. They can be awarded one of a number of types of non-immigrant visas to victims of crime, to witnesses of crime, to people who've been trafficked. There is even a formalized form of prosecutorial discretion called deferred action. Any one of a number of things can happen under the Immigration and Nationality Act, and the Department of Justice and Homeland Security have discretion. They can choose which one of these happens. And what the SB 1070 laws try to do, essentially, is to pick one, voluntary departure, and say, you have to leave or face the consequences. And that's just not how the Immigration and Nationality Act works. It doesn't say you have to leave or face the consequences. And it's also the wrong person, the wrong entity making the choice. It's not the states. It is specifically the federal government. And you could say, well, so what? There are these possibilities, but basically the law says these people are undocumented and they're supposed to go. But the reason that argument isn't persuasive to me, and one of the reasons, is the history. So we had, of course, an amnesty in 1986, and that was a big thing. But in looking at immigration policy over the years, it turns out we've had 6 major amnesties since 1893. It seems that every now and then, every so often, periodically, Congress grants everybody who's here unlawfully but who hasn't committed a serious crime the right to stay. And this is a persistent feature of American immigration policy, and there's no guarantee, of course, that it'll happen again, but this is what comprehensive immigration reform is supposed to be, and Presidents Bush and Obama and some of the Republican candidates anyway have said that something like this is coming. So essentially, SB 1070 and similar laws are an effort by the states to take away the discretion that's given to the federal government under the Immigration and Nationality Act, and to sort of forestall, by getting rid of these people now, forestall something that Congress has done regularly, which is say, all right, if you've been here for 5, 8, 10 years and have successfully integrated yourself into society and haven't committed crimes and have been productive, you get to stay. That's been our policy.
Okay, but I'm still not exactly clear on how it can be that states are preempted here. I understand, for example, in teaching constitutional law, right, we teach about the anti-commandeering doctrine. The federal government can't tell the the local sheriff that he has to conduct a background check or otherwise enforce federal gun laws. But here the states are volunteering to enforce federal law. What's the constitutional problem with that?
Well, two things. One is there's a number of constitutional problems here. One is that the states don't have inherent authority over immigration. The states, according to the Supreme Court, have no sovereign right to regulate immigration. That was a problem in the Articles of Confederation. One of the reasons we went to a constitution is because of the disparate state immigration and citizenship policies under the Articles. So we have a uniform rule of naturalization and a federal responsibility for immigration. And the law in the Supreme Court has developed along the same lines, recognizing that this is an exclusive federal responsibility. And so preemption is one of the ideas here, but even without preemption, even without a federal statute that the state law is somehow inconsistent with. The states can't do this. I believe this because in 1876, the first important federal constitutional decisions about immigration said that New York and California could not regulate the ports, the disembarkation of passengers at the ports, even though at the time there was no federal immigration law. So it can't have been a preemption problem. There was no federal statute for these to be inconsistent with. But the Supreme Court nevertheless said unanimously, this is a federal responsibility. If there is going to be regulation in this area, it has to be done at the federal level. That was 1876. In 1976, in Decanis versus Bika, another unanimous decision of the Supreme Court referred to a regulation of immigration which Congress itself would be powerless to authorize or approve. So the Supreme Court has said, even if Congress said, you can do this, if it's a regulation of immigration, the states can't do it. Now, regulation of immigration, as used in this context, is sort of a technical term. It means determining who can stay, determining who has to leave, and determining the terms upon which a lawfully admitted alien can stay. But much of what SB 1070 and similar laws try to do is a regulation of immigration because it's determining who has to leave. And it's not doing that substantively. The innovation that they have come up with, that the designers of these laws have come up with, that they think makes it work, this is their hope, their legal innovation, is we're not determining who has to leave. We're drawing on the Immigration and Nationality Act for that. We're applying federal standards. We're not applying our own standards. But my argument is that it's a regulation of immigration even if you apply federal standards. Even if California passed a law saying, exclusively applying federal standards, we can issue visas. That would be a regulation of immigration because they're still determining who can come in procedurally. And by the same token, for them to say, we're going to determine who has to leave by punishing people, by putting them in prison if they don't leave under our laws, that it strikes me as a regulation of immigration. And what's wrong with it? What's wrong with it? Well, part of the reason about what's wrong with it is the same thing that's wrong with commandeering. And this is a conservative idea. In Prince versus United States, the Supreme Court said that state and local law enforcement authorities couldn't be compelled to help carry out a federal regulatory regime. That would be commandeering them. They have a 10th Amendment right not to be commandeered. But in addition to that, the Supreme Court said, through Justice Scalia, a second thing that was unconstitutional about that was that it took away the president's right to enforce the law. The president has executive authority to carry out federal laws, and Congress can't get around that simply by asking someone else to carry out the laws. And so my argument is that Congress in the Immigration and Nationality Act has not asked the states to help carry out federal immigration policy. But even if they did, it would be unconstitutional because the president has the right to carry out the laws. And we can argue about whether the Public Company Accounting Oversight Board, which is supervised by the SEC, is in the presidential chain of command or not. The Supreme Court said that it wasn't, 5-4. But no one argues that the Fulton County prosecutor is in the presidential chain of command. No one argues that the Maricopa County prosecutor is in the presidential chain of command. They're clearly not. A state prosecutor can't be supervised or removed by the president at all. And so under even the most liberal view of executive authority, to say we're going to give state prosecutors unfettered and arbitrary authority, far more authority than any U.S. attorney has. You can do whatever you want. That is, it seems to me, an impermissible delegation.
Okay. But Doesn't federal law actually do that, right? There's a program whereby local jurisdictions, Cobb County, for example, can participate in the enforcement of immigration law. Are you
Yes,
saying those are unconstitutional?
Well, some people say they're unconstitutional. I think arguendo, I'm willing to admit they're constitutional in principle. In any event, it's consistent with my argument, and here's why. There is a provision of the Immigration and Nationality Act that says all state and local and federal law enforcement officials can make arrests for the crime of reentry after deportation. Anyone can do that. And there is a provision of the Immigration and Nationality Act, 287G, that allows state and local law enforcement officers to be designated immigration and customs enforcement officers, and in that role to carry out federal immigration enforcement activities. And the critical part of that is that we're talking about arrests. Why are arrests different from what Secretary of State Kobach, who's the author of SB 1070 and some of these other things, he says, look, they're allowed to do this, so they're allowed to pass legislation. They're allowed to do this, so they're allowed to prosecute. The difference is that when you arrest someone, they go to the U.S. attorney. And the U.S. attorney can say, thanks, but no thanks. And the state and local law enforcement officers, 287G officers, can arrest all the strawberry pickers they want. But they're probably not going to get prosecuted because that's not the policy. The Department of Justice isn't, for the most part, some places they are, but as a general prosecutorial strategy, that's not what they're doing. So they can make arrests, but what SB 1070 says, the genius, the innovation of SB 1070 is, well, we could always make arrests, but that's not working. What we want to do is be able to put people in jail. And so what they're taking here is legislative authority and prosecutorial authority, and that can't be delegated. There's a wonderful case, a Supreme Court case from 1897 called Robertson versus Baldwin, where the Supreme Court makes this distinction, and they say that even in Article III prosecutions, inferior officers and non-federal officers can do preliminary matters like search warrants and arrests, even if they can't do the real thing. Lots of other examples. There's a federal statute that says that state officers can arrest for desertion. They can arrest armed forces members for desertion and turn them over to federal authorities. But that doesn't imply at all, in my opinion, that Arizona could have a law that says active duty armed forces members, we're going to have our code of discipline for them, and you're subject to military discipline, but also Arizona discipline as well. Arrests is a special, limited form of assistance that doesn't imply all of the things that the defenders of SB 1070 say.
See, I would have thought that the reason 287G is permissible is that through the Attorney General, the President is able to supervise the participating localities, right, and to decertify them if they engage in racial profiling. And that for those purposes, the distinction between arrest and prosecution isn't very important, because isn't arresting someone as much at the core of executive power as prosecuting someone?
Well, I forgot to say the executive supervision part. Yes, so that is very important. The statute, 287G, says that they are under the supervision of federal authorities. So they're not being given a general warrant or a writ of assistance that they can just freelance and do whatever they want. A 287G officer is in the chain of command, and they have to follow their federal bosses or pay the consequences. Mm-hmm. So that's true, and I don't think that is particularly unconstitutional. It may be that the supervision, is some evidence that the supervision isn't what it's supposed to be, isn't what it should be, and that it may turn out to be a naked delegation of authority. But in principle, I think it's okay. And in terms of is who gets arrested at the heart of the executive authority, I don't think so. We have citizens arrest in this country. A private citizen can put you under arrest based on probable cause. And if there is probable cause and in some jurisdictions some other requirements, there's no civil liability. And so I think we have pretty systematically differentiated arrest from legislative and prosecutorial authority. Arrest is something minimal. The authority to actually charge someone or imprison them is different, and I think non-delegable.
Although I think President Clinton might think that Ken Starr was not exactly subject to his supervision and control, right? And we allowed the independent counsel to proceed. And in fact, prosecutions for contempt of court are conducted by officers not appointed by or accountable to the president, but rather appointed by the judge. In the case, right, Judge Clement can correct me if I'm wrong about that, but right. So I mean, there are sort of exceptions. It just strikes me that maybe the better footing to put 287G on is the fact that it actually preserves presidential discretion.
Well, I'm not particularly keen on preserving 287G, but if 287G is preserved, then that's why it's constitutional. But you know, the fact that the independent counsel law has gone away is an example of a cluster of ideas that explain why this claim, well, isn't more enforcement good? What's wrong with having more enforcement of immigration law or any law? And the answer, the pushback, often from the conservative side of the court, which is why I don't see the Supreme Court as necessarily the savior. They're going to overrule the Ninth Circuit. Well, the Supreme Court has been very skeptical of the idea that more enforcement is always good. And I'm thinking here of implied private rights of action based on a federal statute. And even in a situation where an individual has standing because they're directly affected by the violation of federal law, the Supreme Court says in the absence of an explicit private right of action, then we think that the check imposed by prosecutorial discretion is what Congress intended here. Mm-hmm. And so prosecutorial discretion is as the full Supreme Court has said, and Justice Scalia with great emphasis, is part of the Immigration and Nationality Act. That's why there's very limited judicial review, because they say Congress meant for the experts to deal with this. They gave it to them. And to me, the same rationale applies to the states. This is not a statute that says everyone can jump in and participate as much as they like. It's a statute that really is aimed at giving power to these specific agencies.
Mm-hmm, mm-hmm. So then, even though the states are enforcing the same policy, in fact, enforcing the federal policy, they would say, the fact of their enforcing it is an obstacle to the federal scheme, which means to reserve that power to the president. Right. So there's this superficial point. How can you be an obstacle if you're just helping the federal government? But in fact, it can be an obstacle because the way the states enforce is at odds with the way the federal government enforces.
That's right. The federal government, the reason for this extreme deference to federal authority in this context is because of national security and foreign policy. That's why immigrants have such a hard time when they're challenging portions of the Immigration and Nationality Act, discriminatory portions of the Immigration and Nationality Act. The Supreme Court says, we can't get into this. This is political. This is for executive and congressional people to work out, and who knows if we got into it, what terrible consequences would ensue. And that rationale clearly applies to the states. It applies to the states in particular because there's an existing set of methods for the states. If the states wanted to do all the immigration enforcement they wanted, they could. They could do that through 287G and by financing special assistant U.S. attorneys. which is authorized by statute, and it happens in particular areas of enforcement that they think it's important. The problem with 287G and with special assistant U.S. attorneys, you could take every deputy county attorney in Maricopa County, which is Phoenix in Arizona, and say, we want you to work on immigration cases, and the U.S. attorney could do that and might do that because they're overwhelmed, and there'd be tons more cases. But they would be cases done the way the U.S. attorney and the Department of Justice and the president wanted them to be done. And that's not what they want. They don't want to help the federal enforcement policy. They want a different policy. That's why they want to pay for this. And this is a much more expensive policy for the states, because when you convict someone under SB 1070, they go to state prison, which the state has to pay for. Why not do it through 287G and have the federal government pay for the imprisonment? Well, because it's going to be a different group of people who's in prison. They're not going to do it the way you want it. And so that's the reality here is that I think is that that this is not the states helping with the federal enforcement regime. It's the states saying, we don't like the federal enforcement regime. We want a different one. Let us do it our way.
Okay. Yeah, thanks. And Deep, I wanted to talk to you a little bit about the application of some of these principles in other contexts, right? So the most recent Supreme Court case in the area is Chamber of Commerce versus Whiting, which dealt with Arizona's laws regulating employers and the employment of undocumented immigrants in the state of Arizona. And so I'm wondering if you could talk a little bit about the other kinds of laws that are out there other than sort of criminal enforcement, and what Whiting portends for those laws, and also what it might tell us about the Arizona versus U.S., the challenge to SB 1070.
Okay. So first of all, thank you for having me here. I think my comments will, in answering your question, Neil, will really just take off from where Jack's left off. To the question, the specific question, that is, what does Whiting teach us, and what does it have to say, or does it alter the way in which we might understand other types of laws like SB 1070? My short answer is no. We can all go home now. No, but it's a question worth asking only because at its highest level of abstraction, the Whiting case is about a state victory or state law victory as against a claim of preemption, right? That is, that there's a IRCA regulated employer sanctions. You have a state entering the employer sanctions market and surviving against a claim of preemption. And so as restrictionists did claim in the wake of Whiting, so you had statements by, for example, Secretary of State Kobach, plus organizations like FAIR and Numbers USA making the claim that, well, this is clearly opening the floodgates. Whiting means that SB 1070 and laws like that are surely to be held constitutional by the Supreme Court. The Supreme Court's recognizing a new era of state involvement in immigration. The issue brief that I wrote for ACS argues that really Whiting tells us very little because the legal analyses are really non-transferable, partly because of some of the comments that Jack made. When you think about what's happening in Whiting in the business licensing area, you have in the Immigration Reform and Control Act of 1986 a specific provision which arguably has a written exemption for laws like Arizona. I think that's a contestable argument in the first place. That's why you have a divided Supreme Court in Whiting. But at least there's textual basis. You don't really have to get to larger constitutional questions, significant interpretive questions. One can simply look at IRCA, which says states shouldn't be doing sort of employer sanctions except in the way of licensing. And arguably, LAWA, the Legal Arizona Workers Act, is a licensing type of law. But the Supreme Court, I think, is very clear in Whiting that its analysis is limited to the comparison of the specific Arizona E-Verify law to that specific provision of IRCA, and really does not go beyond that in any way. And in fact, takes great pains to suggest that its opinion is not going beyond the specific comparison of state law to the federal employer sanctions law. When you think about unilateral entries of states into the enforcement arena, which is what you have in SB 1070, non-supervised unilateral assertions of state authority to enter into enforcement area, you have very different bases upon which the state has to defend its policy. There's no exemptions clause in the INA that would allow that form of participation. So when you think about broadly how states have defended laws like SB 1070 or the Alabama law, in the way I see it, it sort of breaks down into three broad arguments. One is, as Jack mentioned, sort of a mirror theory argument. That is, we're doing exactly what the federal government wanted us to. Our goals in deportation are exactly what the federal government would have done, and therefore we're doing it. This is the same thing. Second argument is that well, the INA allows for state involvement in enforcement in some ways, and this is sort of permission for a larger set of state participation in enforcement. And then the third argument is an inherent authority argument. That is, it really doesn't matter whether we're trying to mirror federal goals or whether the INA gives us some statutory permission to enter into enforcement. We as states simply have, by virtue of federalism and our sovereign powers, the ability to enter into the enforcement sphere. The first two, I'll just say what Jack has said. That is, that's not how statutory interpretation works, and for very good reason, right? That is, it's really difficult to make the argument that a very specific statutory provision that says you can participate in enforcement pursuant to a written agreement with the federal government in the case of 287G agreements, or you can participate in arrest authority for specific types of things like illegal reentry or harboring of undocumented persons, right? That you can read that as a general statutory permission for entry into the enforcement field. I mean, that would simply suggest that anytime Congress writes something and is specific about it, it's a general authorization, right? Which is not how statutory interpretation works. It sort of defies logic to think about statutory interpretation working in that way. The mirror theory is also similarly, it fails fairly quickly for some of the reasons that many of the reasons that Jack mentioned. One, the fact that state laws mirror federal goals has, outside of the immigration context, been held by the Supreme Court as not an argument that's going to save any particular piece of state law. So the matching of goals is irrelevant in many ways to the preemption analysis. And then second, just sort of practical questions of resource allocation, and I would take it perhaps a step further than Jack. One way of describing what Arizona is doing with SB 1070 is reverse commandeering, right? That is this idea that if you look at Pew Hispanic Center research, they estimate that probably Arizona has somewhere between 400 to 500,000 unlawfully present, unauthorized persons living there. If you look at John Morton's most recent memos of what the immigrations enforcement, how many people they can deport running at capacity in a given year, it's somewhere around 400,000 persons, right? So that's using all the budgetary allocations. That's running at record high numbers of prosecutions and deportations over the last 3 years of the Obama presidency. So technically, if Arizona were to actually affect everything it could with SB 1070 and use all its arrest power to bring in everybody that it could to federal attention, first state attention, then federal attention, you'd essentially have occupy the entire prosecution and deportation system with just Arizona people from Arizona, which uses significant federal resources, and for the reasons that Jack mentioned with regards to the president's take care power, seems to be an impermissible intrusion of state authority on federal discretionary matters. And so you have this sort of resource allocation problem that's going to happen there with that sort of, with allowing SB 1070 to do this sort of thing, which doesn't happen in the business licensing area, where with E-Verify, at least according to the U.S.'s own briefs, the amicus briefs that it submitted in the Whiting case, that individual state use of the E-Verify database system is not going to be an overburdening of federal resources. That may be contestable, and as Justice Breyer pointed out in the Whiting case, the E-Verify database has significant error rates in it, and so we might be worried for other reasons, but maybe not from a commandeering of federal resources perspective. Which leads me to, if those two don't work, the only other argument that you really have for SB 1070, an argument that you don't really need to get to in the Whiting or E-Verify area, because we, as the court says, states in the Whiting case are traditionally thought of as having employment, control over employment relations, which is what E-Verify arguably does. In the enforcement context, if you can't rely on mirror theory or some sort of INA statutory permission, states have to rely on an inherent authority position, which the Supreme Court has never accepted, that states have this authority inherent authority to engage in this sort of activity. If you look through the briefs in United States versus Arizona, the one real piece of authority that gets cited is a 2002 OLC memo, which is sort of this odd memo that says states have an inherent authority to act with regards to immigration enforcement, but that memo is one memo against a sea of other precedent that says otherwise, including prior OLC memos, which take the exact opposite position and come to the exact opposite conclusion with regards to the inherent authority of states to enter into that field. So the end point here is basically, I don't think that Whiting has much to say at all about how the court is likely to view SB 1070 or other unilateral entries of states into immigration enforcement schemes.
Okay. What about outside the enforcement context? So education laws like the Alabama law has significant education components, or housing laws like those at issue in Hazleton. What does Whiting tell us about those settings?
Yeah, I mean, I think that I still don't see them as Whiting as saying that much about either of those two laws. I mean, the interesting thing about the education aspect of it is that one might have thought that question was decided in early 80s with Plyler versus Plyler, right, in the Plyler case. But maybe this is sort of a side point that goes to some of the points that Cecillia was making, is that it's fascinating to me that in the immigration area with these state laws, that the existence of Supreme Court or federal court precedent really, it doesn't act as that much of a deterrent to the proliferation of these state laws. And that's probably because of the way in which they're generated, right? As Cecillia pointed out, you have model legislation that's sort of shopped from jurisdiction to jurisdiction until you get sort of willing jurisdictions that are going to enact them. And so the idea that Plyler exists is really not. It wasn't a real deterrent to California in 1994 when it enacted Prop 187, which was then overturned by a district court. But then you see Alabama doing exactly the same thing, right? That Texas tried a couple decades ago, and then California tried 2 decades ago. So you don't see a lot of stopping because of Supreme Court precedent. But to your point, again, I think that when you look at Whiting, the context is so specific, and you have very clear statutory or arguable statutory allowance for entry into the business licensing field that you don't see in any other place, right? And I think that the district court and the Third Circuit opinion in Hazleton are very clear on this point with regards to the housing and rental ordinance types of laws, and one could say the same thing about the education context. And there you can add Plyler and the California Proposition 187 case to that as well.
Okay, thanks. John, I think a lot of this discussion sort of points at you in that, a lot of this discussion has to do with what do we make of federalism values, right? So how broadly should we interpret federal law? How narrowly should we interpret states' residual sovereignty or state authority to either directly reach immigration or to reach the immigration effects of things states normally regulate, like employment or education? And that itself, I think, is something that is largely informed by the trajectory of the court's jurisprudence in federalism. So I was wondering if you could talk a little bit about where the court is with federalism and what ramifications that has for how the court is going to treat these kinds of questions about state authority.
Sure. I mean, first of all, I just want to reiterate one thing Neil said earlier, which is I was invited to be on this panel because ACS wanted one person who was not an expert in immigration law, and I certainly qualify on that score. So, yeah, I mean, the only thought I've ever had substantively about immigration law, I mean, call me crazy, but I think Congress should figure out what immigration policy we really want to have and should enact it, and then the executive should enforce it. The current system under which we have one official policy on the books, but we don't really enforce it, has always struck me as somewhat absurd. But to answer your question, it is interesting if you look at the trends in federalism jurisprudence over the last 20 or 30 years. There's clearly an increasing receptivity to arguments about state authority, which leaves me feeling somewhat about cases like the current SB 1070 case, somewhat the way I feel about the healthcare cases that are also pending before the Supreme Court.
Customs and Border Protection and Immigration and Customs Enforcement officers to rely on race in making reasonable suspicion stops. I think Camargo is sort of unpersuasive in its specific efforts to distinguish Brignone-Ponce, because there's lots and lots of undocumented people in California and Arizona. I think it's persuasive in saying that you shouldn't take race into account, but that's where we need to get sort of a direct overruling of that Supreme Court holding, because I don't think you can distinguish it away.
Could I ask a related question, and this is a genuine question, I don't know the answer. Putting aside stops for a moment and focusing on actual arrests, we were reminded by a couple of big Supreme Court cases recently that the United States has an international treaty obligation to determine the citizenship of an arrestee, because if the arrestee is a citizen of another country, then the Vienna Convention on Consular Relations requires us to notify that person's consul. So presumably, now that this is in everybody's mind, the states and the federal government are creating some apparatus that will permit local police officers to determine the citizenship of someone they arrest. Would it be much more different, much more burdensome to set up a similar apparatus that would permit them to determine immigration status?
Well, the federal government is trying to implement such a system through the Secure Communities program, where they're going to systematically screen people electronically who are booked into jails all through the United States. They've said they're going to roll this out by 2013. So I think that we have a lot of new technologies that are coming into play that we're just going to have to contend with. I think on the other side, what we've seen is when officers know they have jail screening available, you see a serious uptick in arrests of Latinos for minor offenses, for things that are normally citable offenses. The Warren Institute at UC Berkeley did a study of a precursor to Secure Communities called the Criminal Alien Program, where ICE would put officers in jails to do this screening. And when that program was implemented in Irving, Texas, there was the rates of misdemeanor arrests of Latinos skyrocketed in that community. So people who normally would get a ticket for speeding, if at all possible, the officer would arrest them and take them to jail in order to have them run through that system. So there's a cost in terms of our civil liberties whenever you dial the ratchet up enforcement. And the analogy I use is, look, if the state of Arizona or the state of Alabama decided we are really concerned about marijuana possession, and you could ratchet up enforcement of that. You could have officers stationed on every street corner in downtown Birmingham or Montgomery or Phoenix and say, we are going to do random searches of people's bags, briefcases, because we're so concerned about marijuana possession. Well, there's a price we all pay for that. And I think the price we're seeing right now with these immigration laws is Fourth Amendment violations and racial profiling of people that officers assume to be undocumented immigrants. In Alabama, we see it outside the law enforcement context with the education provision. When Alabama passed a law saying that schools have to check birth certificates of kids who are enrolling in public elementary schools, we've seen a lot of schools single out Latino kids for all kinds of things, calling them out to the front of the class, giving them, documents to explain the law, and these are by and large U.S. citizen children who are being stigmatized by the law. So I think that these are all things that, whatever the answer is on immigration enforcement, wherever you think the dial should be turned, the answer can't be state laws that systematically result in constitutional violations.
Neil, if I could comment on a point that was made earlier, maybe this sort of bridges the gap between some of the comments that Jonathan made and the comment that Cecillia made. With regards to the federalism values of state and local participation in this arena, I guess, I disagree with Cecillia. I don't think it's that clear in the Constitution that that immigration or all aspects of immigration are only federal responsibility. I think that, one could read the Constitution and think that there's some room for state and local involvement, at least in some limited areas. And I'm partially sympathetic to Jonathan's point that Congress could, if it wanted to, end lots of debate by, let's say, or maybe not, I think, stop debate, but at least end a lot of debate by passing a law now if it wanted to, right? I think that I agree with that, except I would say the following things, right? That one might make the argument that Congress has spoken very clearly, and we should think about executive enforcement of congressional laws part of that policy, which means that Congress has already spoken clearly enough, and the president has used the budgetary allocation to enforce according to the priorities of the federal government, and that is also what constitutes federal policy, and there's no need for Congress to speak anymore, and so we don't even have to think about we don't have to worry about questions of exclusivity and constitutional sorts of preemption questions. But the other question you asked had to do with, is there any value to be had from the state and local responses in terms of the broader federalism debate? And here I would say that it sort of depends on what you think federalism's all about. And if you believe that federalism is justified by its ends, that is, it provides certain benefits that, and so that's why we have decentralized decision making, and those benefits are well rehearsed, right? We could say, localized solutions to local problems, more people participating in democratic solutions, experimentation, the possibility of competition amongst competing branches of government. That's why we have federalism, because it produces those ends. Or one might say, it doesn't really matter what sorts of benefits and ends federalism produces. We just care about separation of power or decentralized power for its own sake. We don't really care whether it produces any of these benefits. Now, if you take the first view, that is, federalism is important because of these benefits, then I would suggest that just looking at these laws, there's very little benefit in the sense of that federalism talks about state and local ordinances benefiting us as a polity. One, because you have significant exportation of costs, which in any successful experimentation, you'd likely want to have a situation in which the states are internalizing costs. But here, this experiment externalizes costs by shifting people outside of the state of, for example, Arizona, and shifting costs to the federal government as well. Replicability is also interesting here because, as Cecillia pointed out earlier, you essentially have a few people who design legislation and shop it, and so it's not like there are jurisdictions learning from other jurisdictions as solutions to local problems and then enacting. In fact, if you look at Hazleton and Valley Park, I believe they were enacted within 4 days of each other, both laws written by the exact same person. In fact, all of the laws are essentially traced back to the same person or group of persons, and so they've been created in advance, seemingly designed to push the envelope just a little bit with each law, which is why if you follow news reports of all these laws, it's without fail, you will see each new law written, and the headline will be blah, blah, blah enacts the toughest immigration law in the nation. Doesn't matter. You can substitute the locality or the state that you want, and so that's why you saw after Alabama, it said Alabama, it's the toughest law in the nation. Although if you looked at Arizona, same thing. Arizona enacts toughest law in the nation. That's because there's slow sort of accretion of the punitiveness of each of these laws. And I think that's a design, I would argue it's a design strategy to shift sort of national debate and the terms of the national discourse on immigration restrictionism. And so, you know, but these are all responses if you believe that the point of federalism is to foster these other values, which I would argue is not happening with regards to these laws. Now, but one could always take, I think, the other position, which is that it doesn't really have to, these are nice values and nice things we might expect, but who really cares? Federalism is just about the pure difference of allocation of power, in which case it doesn't matter if it produces any of these benefits, so-called benefits or not. And here I go back to sort of what I said about the way in which the state has positioned its arguments in the United States versus Arizona case. The two of those arguments, the mirror theory argument and the fact that it's been authorized by the INA to participate in enforcement, are really arguments about sort of a participation in a regulatory scheme. We might describe the states there as acting as servants within the federal regulatory immigration scheme. But the third argument, that is we have inherent authority to do this sort of enforcement, is a conceptually very different argument, right? It's positioning the state as independent sovereign, not as a servant in a broader regulatory scheme. And these rely on very different conceptions of federalism, right? The first two rely on sort of this idea that we can benefit all by this collaborative, decentralized, authority. But the third is, or the last one says, doesn't really matter, right? We get to enact because we get to enact.
So why is it, though, that states aren't competing? Because I've looked at the ACLU website, and it says that it turns out the net impact of undocumented immigrants on public financing is positive, right, in the long run. So if Arizona is exporting costs, it's also exporting benefits. And why doesn't Ohio say, as the governor indicated maybe they would, the welcome sign is open, come here. And Arizona, your finances are already a shambles. You'll be completely bankrupt by having exported this benefit because undocumented immigrants, despite myths to the contrary, do pay taxes, right? Mm-hmm. And taxes that by a number of studies indicate that they benefit the jurisdiction more than they impose costs on it. So why wouldn't that competition take place? Why won't other states say, come here and boost our treasury?
Well, I think, I don't know that states are going to be competing to draw immigrants. I've heard similar statements about Missouri, which now is considering more anti-immigrant legislation. But what I would say is, and I'm sure we'll hear about this during the afternoon panel, a lot of these states are regretting their actions in passing these laws. Some of the legislators who are proponents of HB 56 are now working with the Attorney General and the governor to try to figure out ways how to get out of the mess that they found themselves in. They've taken a lot of pressure from agricultural concerns in the state, construction industry, and other business interests, with farmers accusing the governor on nationwide TV of passing something that didn't make any sense. There was a farmer from northern Alabama who plaintively asked the governor, you said that if you pass this law, U.S. workers would step up and pick our crops, and here they are rotting in the fields. And I think we see some of the same buyer's remorse in Arizona with Russell Pierce's recall and the failure of the follow-up to SB 1070, SB 1611, which was similar to the Alabama law that was passed. So I think, as a policy matter, there is a definite downside for these states that are considering this, and I think that's part of the story of the blue states up here that considered legislation but decided not to enact it.
I mean, I'll just say that there is, so this is part of a new research paper that I'm doing with a political scientist using some data from all the places, all the jurisdictions that have enacted local ordinances, all the states that have enacted these sorts of ordinances. One story that you can tell about all of these, right? There's roughly like 92 municipalities in the United States that have enacted anti-immigrant ordinances. There's 25,000 municipalities in the United States, right? And so very small number. and then a significant number of states that you see there. But one story that you can really tell about all of these is that demography explains very little. That is, if you look at states where these are enacted, localities where these are enacted, and you actually crunch the numbers, recency of immigration, language isolation, relative or absolute economic deprivation, none of these factors actually statistically explain or predict the rise of ordinances. The only factor that has any significant statistical effect is partisanship, the right partisan mixture of that jurisdiction and a receptive local official who's willing to promote that policy. And so if you look at where the next large state immigration law is likely to come up, one might look to for North Carolina, which on the map already is blue, but you might see in the next year or two another law being proposed. In fact, you don't even have to look that far. You can look to the Numbers USA website where they, in fact, predict themselves that North Carolina is likely to be the next battleground because, as they write on their website, there's the right mixture of people at the state legislature and the state governor's office in order to enact it. But it's not because North Carolina is, has a significantly higher number of immigrants or recent immigrants or undocumented immigrants or higher language isolation or even relative economic deprivation in comparison to similarly situated states. And the same can be said about at the local level. On the pro side, the same correlation. Usually you just see larger cities tend to enact pro-immigrant legislation. That's much more predictive of when you're going to get pro-immigrant legislation than any other factor that you can control for.
I think at this point we're going to open it up to the audience for questions. So we don't have a microphone to pass around. So if you have a question, raise your hand, and then when acknowledged, stand up and speak loudly. Any questions? Yes.
This is for Cecilia. You mentioned just a little bit about secure communities. What is the difference between 287G and are they the same or?
Right. So Sure. The question was, is what's the difference between 287G and secure communities? 287G refers to a section of the Immigration and Nationality Act, and it's actually one of the sections that we rely on in arguing that Congress doesn't want local and state governments to pass these kinds of laws. 287G says that if the federal government wants to enter into a written agreement with a local or state agency to help enforce immigration laws, it can do so, and has very specific requirements for training and supervision by the federal government of the state or local agency. Secure Communities is a program that the federal government is trying to roll out by 2013, which is different from 287G. It's an automated screening process that's going to happen whenever a state or local jail or prison sends fingerprints out to the federal database to check for warrants, to check for previous convictions, to run a rap sheet, that sort of thing. So what the federal government wants to do is to take those fingerprints, which traditionally have been run through federal or interstate consolidated criminal databases, and also run those through immigration databases. What we've seen with Secure Communities is a number of states and municipalities saying we don't want that program. So it's kind of the flip side of what we're seeing with the state anti-immigrant laws, where the federal government is trying to impose a system of immigration enforcement on local agencies that have said, we don't want this. We don't want this for law enforcement reasons. We don't want it for public safety reasons, because once people know that calling the police can land you in the situation of having your status checked, we're going to have people afraid to report crimes.
Yeah, in the back.
That's a very good question. The 287G program doesn't necessarily, the question you're asking, I think, is broader, and that's the question of when a local or state agency has someone in custody and the federal government wants the person or doesn't want the person, is there a time limit? If the federal government has issued what's called a detainer, expressing interest in the person, federal regulations require that ICE go pick the person up within 48 hours, not including holidays and weekends. So theoretically, there is a limit. One of the problems with the state laws is that most of them have a provision that once a person is in state custody, immigration status must be determined. And then, in the case of Alabama, for example, it requires the agency to hold the person until ICE comes to get him. Well, the law doesn't account for the fact that the federal government might not want the person. And so there's an indefinite period of time in which the state is going to hold the person without any criminal charge, without any notification from the federal government that the person's deportable. And that's a serious Fourth Amendment problem as well as a preemption problem. You know, this is a broader problem, again, than the state immigration laws, because there is a serious problem with state and local agencies holding people without any charge because the federal government has expressed interest. People do file habeas actions, and generally what happens is ICE will immediately come get the person, and then the action will be arguably moot. But it's really a systemic problem across the country because a lot of folks who are caught up in an ICE detainer situation don't have the wherewithal to contact counsel. You know, if they never were charged with a crime by state authorities, they don't have counsel. They're sitting there in jail, and that's why we've seen a number of cases where the ACLU and other advocates have had to file damages actions. We've had U.S. citizens being held for a prolonged period of time because of ICE detainers, not to mention states like Alabama that are holding people without an ICE detainer.
I'm wondering if there's a lot of discussion of federalism, but nobody's really talked much about equal protection. I'm wondering how good the equal protection arguments are against some of these provisions, particularly against the civil death provisions.
Yeah, the equal protection claims have, we've brought a number of different types of claims under the Equal Protection Clause. In Arizona, because we had Sheriff Arpaio basically putting SB 1070 into effect for years before the state passed it as a law, we did bring an equal protection claim alleging that SB 1070 is going to necessarily result in race discrimination in violation of the Equal Protection Clause. In the other states, we've brought equal protection claims alleging that these various kinds of laws are going to result in alienage discrimination, which the Supreme Court has held when states try to discriminate on the basis of alienage, intermediate scrutiny applies, and that the states can't meet their burden of showing that there's a basis for those laws to be passed. Obviously, equal protection is a claim against Alabama's K-12 education provision based on Plyler. In fact, that law goes far beyond Plyler because it attacks U.S. citizen kids who have undocumented parents as well as undocumented kids themselves.
Well, there were a couple of statutes that were passed in the wake of the California experience in the mid-90s that do give the states some level of authority. So there's a couple of statutes that say that say state and local officials of every type, law enforcement and other, have the right to communicate with the federal authorities about immigration. So they can turn people in if they want to. And then 287G10. 287G is mostly the cooperative agreement, but subparagraph 10 is very important here. And it says no agreement is necessary. A, to share information. in the way that I've described, and B, for state and local officers to cooperate with the Attorney General in the investigation, apprehension, detention, and removal of undocumented people. So they're allowed to cooperate with the Attorney General in immigration enforcement. And so that makes me think there's some question about immigration detainers. Are they constitutional? Are they authorized by statute? I think they are by 287G10. But the states, Arizona in particular, points to 287G10 and says, this is authority for us. This is Congress saying, we want you to have an independent enforcement role, and you can do this, and the federal government has to help you out. And I look at it, and I put much, much more weight than does Arizona and the other states on the cooperate with the Attorney General part of 287G10. And I look at it as saying the states can help out if they want. They can't be commandeered under Prince, can't be forced to do it, but they can help out in a federal enforcement program. And so when the federal government says, stop doing this, please, that everything that happens after that is not cooperation with the Attorney General, and it's not authorized. So that's the debate. I mean, there is a U.S. Supreme Court case that's not irrelevant here called Mueller versus Mena, which was a search warrant case, and the Supreme Court sort of in passing said that the state officers did nothing wrong in asking the people who were being detained pursuant to the search warrant their immigration status. Nothing came of it, but you know, the states look at Mueller versus Mena, and they look at 287G10 and the other bits and pieces, and they say there's this general invitation to the states. Congress wants us to do whatever we want, and they want the federal government to pay for it. And I think that there's a little tiny something there, but that they're taking it way too far, and that's the argument that I'm sure Attorney General West is going to make.
Great. The legal analysis we're hearing this morning seems predicated on the idea that there's a federal government policy and then there's these various state policies. Just wondering how y'all see what the impact you think, particularly in the Supreme Court case, what the impact would be on the sort of increasingly public split within the within ICE, within the federal government, with, for example, the ICE union refusing to even send their, have their agents participate in training that's being requested by John Morton. So the internal conflict between, what policy is and then how it's being carried out off of that.
You're talking about the prosecutorial discretion policy of the federal government.
I mean, that's becoming just more and more public, and whether, in making this argument between, the federalism argument and the preemption argument, whether that will have any impact. It may not.
Mm-hmm.
How that argument goes.
Mm-hmm. Yeah, I mean, I think that the prosecutorial discretion conversation is one that's mostly on the federal side. We've kind of veered away from our topic today and talked about secure communities and some of the other federal programs. But, ultimately, I think to the extent the federal government relies on prosecutorial discretion to say that a lot of these programs like secure communities are okay, we see the problems with that in the implementation. The same goes for the states. I mean, in response to the previous question, the states in all of these cases have said, look, we're not removing anyone, we're not deporting anyone, we're simply enforcing state laws here, and that's perfectly okay. And if the federal government decides they don't want to deport people, well, then they don't deport people. And I think that's really a disingenuous argument because, as you say, the problem is people are being detained in the meantime. And so I think that ultimately the idea that the federal government as a whole or as individual ICE agents can decide whether or not these people are going to be put through the removal system is not a basis on which to rest a decision on the preemption claims.
So I think it's a really interesting question. I think it gets to the larger sort of idea of what you want to see as official federal policy. And I do think there's a concerted strategy on the side of of restrictionists or people who support state and local and immigration enforcement efforts to delegitimize any federal action other than congressional action, right? And so the only type of federal policy is that created by Congress, and that is the sole meaning of federal policy. That is the legislative policy of the United States. But I think that's a very cramped understanding of what federal policy is, but it's an important strategy if you want to have state and local ordinances survive preemption attack, right? Because you want to say that the federal enforcement efforts, if they don't go all, if they don't deport everyone that's deportable, let's say, then it's a violation of the stated federal policy, right? That's one way to understand it, is that the executive and Congress are now in conflict with each other, and the executive is in dereliction of duty, right? But the way in which the United States frames it in their briefs in Arizona, and the way in which I think we would see in all other regulatory areas, is that the enforcement, discretionary enforcement, prioritized enforcement, even if that means individual agents are going to forbear on prosecution even when they could, right? The point that you're making with regards to those memos, is in fact the policy, the federal policy. It is both the decision to make certain people deportable, and then the decision to execute that law as against in using this order given our limited resources and time.
Right, and I think the answer is easy, because Congress has said in the very first section of the Immigration and Nationality Act that they're delegating the enforcement of the whole act to the Attorney General and to the Secretary of Homeland Security. So I think that the state's argument that we have to look to what Congress wants and not what this administration wants, which is a constant refrain, that the answer is simple. You look right in the first section of what Congress said.
Speaking of limited resources and time, ours is up, but join me in thanking the panelists for an excellent discussion.